Hello, everyone, and welcome to the Princeton Open Campus Coalition's first event of the semester. My name is Zach Gardner, and I am a junior studying politics, and I am the president of the POCC. What, you may ask, is the Princeton Open Campus Coalition? We're an undergraduate student organization that is dedicated to fostering a campus environment at Princeton University that is free of fear and intolerance. We value dialogue as our greatest tool, and truth-seeking as our ultimate aim. If you have any questions about the POCC or would like to be added to our email list, feel free to email me at zachgardner@princeton.edu. And also thank you to Princetonians for free speech for co-sponsoring the event, getting the yummy cookies that I'm sure you grabbed on the way in. And if you did not, we'll be there waiting for you when you go out. So grab as many as you think you and your roommates will desire. And arranging the event logistics and advertising, none of this would have been possible without them. In Federalist 78, Alexander Hamilton wrote that of the three branches of government, the judiciary was the least dangerous to the political rights of the Constitution because it will be least in capacity to annoy or injure them. Unlike the president, who has the power of the sword, and Congress, which has the power of the purse, the judiciary has neither force nor will, but merely judgment. Our history has ultimately proven Hamilton's predictions insufficient. It seems that every day brings a different story about the Supreme Court, accusations of professional ethics violations and misconduct, leaked information about internal court politics, including the premature release of Justice Alito's Dobbs opinion in 2022, allegations of overzealous and partisan decisions, and today, national policy of firearms, speech, faith, immigration, abortion, and political power seem to hang upon the court's every word. With these questions in mind, I turn now to our esteemed debaters. First is Mr. Adam White. Mr. White is the Lawrence H. Silberman Chair in Constitutional Governance and Senior Fellow at the American Enterprise Institute, where he focuses on the Supreme Court and the administrative state. He is also the co-director of the Antonin Scalia Law School's C. Boyden Gray Center for the Study of the Administrative State. And in 2021, he served on the Presidential Commission on the Supreme Court of the United States, where he criticized court packing and other efforts to restructure the Supreme Court. He has a bachelor's in business from the College of Business at the University of Iowa and a JD from Harvard Law School. Before his career as a scholar, he served as a law clerk to Judge David B. Santel at the United States Court of Appeals for the D.C. Circuit. Second is Professor Kermit Roosevelt. Professor Roosevelt is the David Berger Professor for the Administration of Justice at the University of Pennsylvania Penn Law School, where he focuses on constitutional law and conflict of laws. A prolific writer, Roosevelt has authored a number of law review articles, books, and even novels, including In the Shadow of the Law from 2005 and Allegiance from 2015. He also served on the Presidential Commission on the Supreme Court along with Mr. White, after which he penned an article supporting proposals to pack the court. He received his AB from Harvard University, we'll forgive you for that one, and his JD from Yale Law School, we will also forgive you for that one as well. But after receiving his degrees, he clerked for Judge Stephen F. Williams of the United States Court of Appeals for the D.C. Circuit and for Justice David Souter of the United States Supreme Court. And with the topic and guests introduced, it's time to debate these important issues. Please give it up for our two guests. Alrighty. So, hello? There we go, it's on. Like in any debate, it's important to establish first principles. And again, thank you so much for being available to come debate these interesting issues. What then, if we're talking about first principles, is the proper role of the federal judiciary in the American constitutional system? What is the proper role of federal judges in their individual capacity? And what is the proper role of the institution that we're all worried about, which is the Supreme Court?
We got like 5 hours, right? Kim, would you like to go first, or shall I?
Sure. Okay. So this is a debate, not a panel, right? So we're supposed to disagree, and I think we will end up disagreeing, but I'm not sure that we're going to disagree on first principles. I think there's a sort of a baseline of agreement on a lot of things, and then when you start talking about particular issues, maybe it gets more complicated. But so first principle is like, what is the federal judiciary for? I think it's there to say what the law is, to enforce and apply federal law, to ensure the supremacy of federal law, to resolve disputes between individuals, all of the sort of basic stuff that you expect judges to do. And then the Supreme Court is a little bit different, I think. So the Supreme Court is there to ensure uniformity of federal law and uniform interpretations of the federal Constitution. And most notably, I think the Supreme Court is different from lower courts in that it has to make rules for lower courts to apply. So the Supreme Court is not really just in the business of resolving disputes between individuals. It sometimes talks about itself like it is. But one of the main things that the court does is it crafts doctrine. It creates the tests that lower courts are going to apply to figure out whether some constitutional provision forbids something. So that does make it a little bit different. But, again, fundamentally, like, it's a court. It's supposed to apply the law. It's not supposed to make the law unless we're talking about federal common law, of which there's little. So I am not going to give you like a wild-eyed judges should do the just thing kind of account. Like, I start with as first principles, I think, in much the same place that Adam will.
I mean, it'd be pretty wild if I just completely disagree with you now. No, I agree with that completely, and I would just add a couple more things. First of all, since you started with Federalist 78, I'd say it's always important to ask what's the role of the Supreme Court in a constitutional republic. And Federalist 78 points out that this actually points in two different ways, or two sometimes ways that are in tension. Yeah, the court says what the law is, to use Marbury versus Madison's famous line. But Hamilton makes clear in Federalist 78, the Supreme Court needs to strike down laws as a last resort, not a first resort. That's how I'd put it, at least. That, yeah, the court has to sometimes declare a law unconstitutional, but it should always make every effort first to try to find a construction of the law that avoids the constitutional question. So from my sense of the Supreme Court in particular, the federal judiciary, but especially the Supreme Court, is to tread very lightly in politics and to minimize its footprint, intervening only when necessary. And related to that, and this gets to the point of neither force nor will but merely judgment, the court is supposed to be the slow, deliberative, reactive body, right? It doesn't have will like legislature. It can't wake up and say, what do we want to do today? And today the legislature would say, well, nothing, we're going back to bed. But Congress gets to decide what it's going to do every day. The president has force. He actually has the actual arm of government that enforces the law, has the power to bind people up, put them in jail, and so on. The court doesn't have any of those things. They have to wait for these conflicts to come to them. And both of those are, I think, are crucial to understanding the function of the court as it goes about doing what Professor Roosevelt described.
That's great. Thank you so much. And I think it is actually a great point of agreement to agree on first principles before then delving into the ways in which you will both disagree on these questions.
We'll disagree about second, third, and fourth.
Second, third, and fourth principles. Well, on the first ones, we're in agreement. So it is no secret that the Supreme Court wields a tremendous amount of influence in American political life. Indeed, the last 3 presidential election cycles have seen the Supreme Court become central to the campaigns of both major parties. Hanging in the balance of the 2016 election was the successor to Justice Antonin Scalia. In 2020, President Trump touted his record of judicial nominations, of which there were many, while future President Biden committed to nominating the first black woman to the Supreme Court, which he ultimately did in Justice Ketanji Brown Jackson. While the Supreme Court has taken a back seat in this election cycle, it's still most definitely in the conversation, and it will most likely become a hot topic of conversation depending on who wins the presidential election and what decisions certain Supreme Court justices make about their futures on the court. This background established, where did this all begin? At what point did the Supreme Court establish its modern central role in American political life? And who might be to blame for it, or maybe not to blame, but be the root of some of these issues?
Can I go first this time? This has been present from the creation, and I think it's very important to understand, even as we're debating these things now, debates about the Supreme Court's power and proposals to structure or restructure the courts, they are timeless in American politics. They go back to, it's because Congress can construct the federal judiciary under our Constitution. It goes back to literally 1789. But the first time the political parties sort of changed control of the White House and Congress, you immediately saw both the Adams administration leaving office and the Jefferson administration coming in, fights over the Supreme Court. These are fundamental disputes in American history. There's no way around it. There's always a risk, I'd say, at any given moment in time, to pursue structural reform in pursuit of a more temporary political goal. I'm not saying that's what's happening here, certainly not with my friend Professor Roosevelt or others. But this has been a bipartisan temptation throughout American history. Conservatives who were declaring the court illegitimate in the 90s, conservatives who wanted to impeach justices in the 20th century, all the way back to the beginning of our government. These things tend to gravitate, or these debates gravitate around the Supreme Court because the Supreme Court's always been so uniquely powerful and consequential in American politics.
So we're still agreeing. But I'm sure we'll get to the disagreement. So first, I want to second what Adam was saying about this being a problem from the beginning. There have always been partisan fights over the Supreme Court. Marbury v. Madison has its origin in a partisan fight about the federal judiciary. Not the Supreme Court itself, but the Supreme Court was involved. So, the Republicans canceled a Supreme Court term. The Federalists shrank the size of the Supreme Court to try to prevent Jefferson from getting an appointment. The Republicans enlarged it again. So, yes, it goes way back. I'm not sure that I can think of Supreme Court decisions playing such a large role in American life until you get to maybe Dred Scott, which I think is a really important decision. I'm going to come back to it. I think Dred Scott shows us something very important about, when the Supreme Court does the wrong thing. Because I tend to agree with what Adam was saying before about judicial deference and trying to avoid constitutional issues and not wading unnecessarily into social conflicts. But, sometimes when the court does that, we end up liking it. So Brown v. Board of Education and Loving, people look back on as successes. So there's something good the Supreme Court is doing there, right? On the other hand, Dred Scott's a disaster. There's something bad the Supreme Court is doing there. And I think there's a theory that explains all of this. But to go back to this precise question, who do you blame for it? I blame the framers, because I think that the way that they drafted the Constitution gave us an appointment process that doesn't work. And it doesn't work because of the second thing I blame, the party system. So they didn't foresee the party system. And the process that we have for staffing the Supreme Court might work very well in a world without political parties, but it works very badly once you introduce them.
If you had anything to add?
Oh yeah, I disagree with a bunch of that. First of all, I would say the Supreme Court's decisions were controversial from the very start. One of the very first Supreme Court decisions, Chisholm versus Georgia, over the nature of sovereign immunity, immediately gave rise to a constitutional amendment. Not long after that, the Marshall Court, in a case called Gibbons versus Ogden, really asserts the supremacy of federal power over the states in a way that I think even some of the framers did not expect. I think was correct, but was certainly not unanimous. I cite those two examples because from the very start, the Supreme Court's decisions about the structure of government itself were enormously consequential. The Marshall Court was in many ways completing the founding, a very Hamiltonian and Washingtonian version of the founding, which is the one I like. So yeah, Marshall. But from the very start, it was extremely, extremely consequential. And there was one other thing you said in there that I would disagree with, but now I can't remember what it is. So
The parties, or the nominations process. Those were a couple things.
Esoteric, we don't need to, but I would disagree about the point about the parties, but also especially about the appointments clause process. And this is actually my window into these issues. I started focusing on this about 20 years ago. My law school paper, which ended up getting published, was on the Senate and why the Senate doesn't need to vote on judicial nominations. A paper that nobody except my mother read for 10 years until 5 seconds after Justice Scalia passed away. And then people said, wait, you wrote a paper about how the Senate doesn't have to vote on judicial nominations. We would love to read that. The appointments process was always the tail on a much larger dog at the Constitutional Convention. Every time the framers in Philadelphia recalibrated the powers of the other parts of government, they would circle back to the appointments process over and over again. I actually quite like what they came up with at the end. The idea that the president really does drive this process of selecting Supreme Court justices, judges, executive officers, but the president needs to convince the Senate to go along with it. There's no clear rules that define that relationship. It's really political. But the basic hydraulic forces are crucial. That the president ultimately has the initial responsibility of picking somebody, but he, or maybe someday soon she, has to convince the Senate to come along. I think they struck exactly the right balance.
Anything to add or move on? Yeah, we'll move on to this one. All right. So into the main, the meat of the disagreement that we're going to get to are the proposals that the Commission on the Supreme Court ultimately were discussing and then decided to, in many ways, reject, or at least put a little kind of asterisk on. So the first one, As we all know, the Constitution sets no limits on the number of Supreme Court seats. In Article 3, it reads, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." Not much helpful there from the framers as to how many we might have on the Supreme Court. So while not explicitly mentioned, the power to determine the number of seats on the court has been understood to be the exclusive prerogative of Congress. The Judiciary Act of 1789 established 5 seats on the court. 6 seats on the court, thank you for that. No, I appreciate it. And 13, later on in 1837, that expanded to 9, before soon ballooning to 10 in 1863. And by 1869, the number had been restored to 9, and that has been the magic number ever since. Given this history of expansion, should more seats be added to the Supreme Court? And more importantly, under what set of justifications should such a proposal be considered and approved? Because many of these expansions that have happened throughout the 19th century happened when more territory was added to the United States, circuits were created, and you needed a justice to be kind of the justice administering that circuit. Is it simple dissatisfaction with the legal outcomes, or must there be a higher threshold for change?
All right. I'm not sure this is working. Is it working?
Yeah, it is.
It is? Oh, okay. So first I would say, no, I don't think that just dissatisfaction with outcomes is a justification for court expansion. Because that's going to give you sort of terribly unstable system, and I think you do have tit for tat and so on, and it's bad. And I think there are probably some people who want it just because they don't like outcomes, but most of the time when that happens, something else is going on. So you can think about it maybe in terms of this new constitutional vision comes along and sweeps the country, and this ideology wins the hearts and minds of the American people, and then what happens to the federal government? So when do they capture the presidency? Well, whenever the next presidential election is, which can't be more than 4 years. When do they capture the House of Representatives? 2 years, right? Everyone's up for election in 2 years. When do they capture the Senate? Takes longer. Senate elections are staggered. The term is 6 years, but maybe 4 years. When do they capture the Supreme Court? When does this new movement see its views reflected in the Supreme Court? And the answer is, who knows? Right? There's no timetable. And sometimes, I think, people get frustrated because the court is out of line with where it maybe should be. And I'll try to explain what I mean by that more later. In terms of where the political branches of the government are and where the American people are. And if you look at like the big court packing proposal that people all think about, FDR's court packing proposal, did he not like the decisions the court was making? Yeah, he didn't like the decisions the court was making. Was there something else maybe that was going on that would explain a sense of frustration? Yeah, he got no appointments during his first term. So when the court lags behind or for some other reason doesn't track evolution of American opinion as reflected in national elections and control of the other political branches, then I think people start getting a sense that something is wrong and that maybe court packing is a solution to something that's gone wrong with the appointments process, right? Because I keep going back to the appointments process. I don't think it works very well. And what people are saying nowadays, I think, is not just we don't like the outcomes. Like I would not support court expansion for that reason. But 2 things. One, the court is reflecting the will of a minority. So a minority has captured the court. And to that extent, I'm sort of sympathetic. I think, there is something we can say about what the court should look like. And the current court doesn't look like what it should look like. I'll talk about that more later. But then the other thing that for me is the most important is there's a natural tendency, I believe, when a minority takes power in a democracy for it to try to lock itself in by subverting democracy. And if you think that this current Supreme Court is undermining our democratic political process, then I would say, yeah, court expansion is justified to stop it from doing that.
I would say adding more justices would be a terrible mistake and a disaster. There's nothing magical about the number 9. There's nothing magical about it. As you mentioned, we started with 6, we've been as big as 10. There's nothing magical about 9. If today the court were 7 justices, that would probably be fine. If it were 11, that would probably be fine. 8 or 10, probably fine. I've always found it was interesting that the original court was an even number of justices. It's because they wanted to have, they had 6 justices spread across 3 districts or circuits. New England, Mid-Atlantic, the South. They wanted to get justices from each of those circuits, and they wanted to send justices out to those circuits, deciding, hearing trials and so on. But we've been at 9 for a very long time. And oftentimes when I talk about why we shouldn't add more justices now, why we shouldn't pack the court, I jump right into the tit-for-tat problem. If we actually add more justices, it will be for the first time, not the last. It will be for the latest time, not the last time. That it will unleash an era of legislative tit-for-tat until we have an enormous Supreme Court. But the more fundamental question for me is, would adding justices make the court function better as the Supreme Court? Right? And I said at the outset, hearing cases, right, deciding them. Professor Roosevelt and I, we served on a 36-person group project, and obviously that was a little hard. A 9-person group project, probably not as hard. But I wonder how the court would function, just collegially, deciding cases, hearing oral argument, writing opinions. Would they actually be a better version of themselves if there were 11 justices, or I think it's 16, no, that's not right, 15, sorry, in the Senator Wyden proposal that came out last week. I don't think that would actually make the court function better as a court. I think actually you'd see much more convoluted decisions coming out of the court, much more sort of weird splits of opinions and so on. It might take longer to decide cases. It's hard for me to envision a way in which, just in its actual day-to-day work, separate from the outcomes of the cases or the legal interpretations, how the court would actually function better as a court. I think it would probably start to function more as a legislature in terms of having to make smaller judgments. There's always the constant risk of judgments that don't have clear lines. Again, if you're giving clear rules for the lower courts, I think the Supreme Court will get worse at that. These are a number of the reasons why I'm against court expansion, but my fundamental reason at this given moment in time is I think it is largely among partisans a part of, I guess by definition, a partisan effort to change the court in response to recent decisions that people don't like.
Can I do a quick rebuttal?
No, absolutely.
Okay. Yeah, so one, I don't know whether the court would work better as a court. I'm sort of agnostic about that. Ultimately, I'm going to try to expand the court a little bit with the plan that I have for term limits. It's going to happen. But that's not the same thing as expanding the membership in the same way. Although also I disagree. I don't think we have 9 justices now. And I'll get to that too. But the 2 points that I wanted to make were, one, like the partisan tit for tat, it's going to go on forever, escalating cycle. It's happened in the past, right? Congress has expanded and shrunk the size of the court for partisan reasons in the past. We didn't have the endless cycle of reprisal. And then 2, if you're talking about changing the size of the Supreme Court for partisan reasons, don't start down that path. I think we've started down that path, right? I think when Mitch McConnell says, we will not confirm any Obama nominee, they took the court down to 9, right? And then I think they took it back, they took it down to 8. And then I think they took it back up to 9 when Trump won. So I believe the size of the court has been manipulated already for partisan advantage. And if the idea is, if you do it once, it's going to happen again, then my position is, okay, let's see it happen again.
All right, perfect. Bringing up term limits, because that is the next question on the docket. Another set of reforms, as you just mentioned, considered by the commission was term limits. As I understand it, it is an 18-year term limit is the most popular proposal that I've seen floated, and that'll eventually get you to the point where I think it's every 2 years would be a justice being nominated by the president and then confirmed by the Senate. I read, Mr. White, that you were initially open mostly to the idea when you first began, if that's correct, or at least you were considering it going into your tenure on the commission, but you changed your mind once you began discussing it with your fellow commissioners, and you, I guess, found religion in a way and decided it would be a bad idea. Yeah. You came into it, I think, very dead set on term limits being a good proposal to consider, and you've become one of the most vocal proponents of establishing term limits for the Supreme Court. So, 2-part question. Would such term limits be achievable with mere congressional action? There's the constitutional question as to whether or not Congress can pass a statute declaring this, or if this needs a constitutional amendment because of the language that justices shall serve in terms of good behavior. And B, would it improve the public's perception of the court as an impartial institution if we were to have less of an emphasis on, as to your point, holdouts and reducing it, as you said, to 8 or increasing it to 9, depending on a presidential election being on the horizon?
we talk about the constitutional stuff first and then get back in, or what order do you want to take it in?
Sure, yeah.
I mean,
Let's do that.
I'll make the argument against it first. And what you said before is true. When I came to the commission, I had already was on the record saying I was against court expansion, court packing. President Biden knew what he was getting with that when he appointed me. On term limits, I didn't have quite as fixed an opinion. For almost 20 years, there have been varying academic debates about this. Akil Amar and Steve Calabresi, 20 years ago, had written a piece in favor of term limits for Supreme Court justices. And I was sort of open to it, maybe even inclined towards it. I always thought it would take a constitutional amendment, but I thought it was worth discussing because some of the benefits of judicial term limits, I think, are undeniable, and they have to be taken seriously. At least two of them. One, when we first created the Supreme Court and justices had life tenure meant basically maybe appointed at 50, served for 8, 10, 15 years. I'm just spitballing here, but what it was not was get appointed at 40 and serve till you're 90. So thanks to the wonders of medical technology and the changing Supreme Court politics that have sort of taken the age of justices down and down and down, obviously life tenure means something different than it used to. And we got to take that seriously. And then the second thing I worried about and continue to worry about is strategic retirement. The idea that justices, because of the polarization of political parties around things like originalism and constitutional methodology, we meet a justice when he or she is standing next to the president who's appointing him or her, and the last time we see them is when they're at the press conference next to the president who's going to appoint his or her successor. And the justices sort of generally pick who they're going to retire under. And obviously that increases the partisan appearance of the justices. There's no way around that, and I think it's a real problem. I tend to like it about 50% of the time. But it's no way to run a country. It is a real problem. The virtues, at least those two virtues of term limits for justices, I think are undeniable. The downsides are what worry me, and they're less obvious, I think, and we'll talk about that a little bit later. I'll just say on the constitutional question, I do not think this can be done without a constitutional amendment. The constitutional text says that the justices, I guess I use the word judges there, shall hold their offices during good behavior. And that's been understood from the very beginning as life tenure. I've not seen any serious challenge to that until very, very recently. It was taken for granted that the justices would serve until they retire, die, or impeached. And there's a reason for that. And again, this goes back to Federalist 78. Hamilton said that we need to attract the right kind of justice with the right spirit of independence. You have to get the best kind of lawyers, the ones who know the law inside and out, who will be bound down by the law and by precedents. And to get that kind of person to give up their legal practice, you have to give them life tenure. But more than that, I think he understood you don't want them dipping in and out of this. You want somebody who's going to commit to it as the capstone of their career and serve for a long time. It wasn't always true. John Jay retired, the first Chief Justice, left pretty early to run for governor of New York. But before long, you had the justices staying for a long time, and it was basically the end of their career more often than not. But one more thing, and I think this goes overlooked. Look even before the Constitution, look at the Declaration of Independence. Among the litany of complaints that the founders had against King George was that he made the judges dependent upon his will for their tenure in office. That at the founding era, one of the problems was that the judges had to constantly look over their shoulder or whether they'd be pulled in and out of court, on or off of the bench, I guess off the bench, just by political will. We don't have that problem anymore. We don't have a king. But I see a real analogy now to the idea that the political sovereign today, Congress and the president through their lawmaking power, that suddenly judges will be dependent upon the transitory will of a given Congress and president to decide how long their term as a justice would be. Now, the fundamental debate between my side of this issue and my friend's side of the issue is what counts as the office. What's the office of a justice? And maybe you could change the duties of a justice on the court, have them hear one kind of case, and then maybe not hear those cases later, constitutional cases, but they'd still be a justice, they'd still have an office. Not to get out ahead of my friend, but I'm not convinced that you can strip a justice of his or her main powers to hear appeals and rule on constitutional questions without changing the fundamental nature of the office. And the idea of putting the justices sort of on a senior team or a backbench where they'd still be justices, they just wouldn't hear most cases. I do think that violates the basic rule that the justices have their offices until death, retirement, or impeachment.
Great. So I'm going to say a little bit maybe about the policy arguments in favor of term limits and then the constitutional ones. So one of the things that my friend Adam was talking about was judicial independence, which I think is super important. And yeah, we absolutely do not want the judges dependent on the will of the political branches for their time in office or their salaries. That's a bad thing. Lengthy fixed terms, to me, don't pose a problem there. And there is no advanced democracy in the world that does life tenure. Lengthy fixed terms is enough for all of them for their apex courts. I don't think there's a single U.S. state, with the exception of Rhode Island, that does it. And we don't think of Rhode Island as really a model in a bunch of ways. No offense to anyone from Rhode Island.
Akeem Omar said the same thing in New York last city. There's like a burgeoning or the Bay Staters, the Ocean
Well, they're a
Staters.
little corrupt, right? Anyway. So I don't think that there's a threat to judicial independence. So the downside, I'm not that worried about. Now, what's the upside? We've just been talking about how powerful and important and influential the Supreme Court is and how it sets policy on a whole bunch of issues. And it tells the American people, what you can and can't do. It's one of the co-equal branches of the federal government, the judiciary. It has a lot of power. So how should you staff that branch of government? Well, here's one idea. We could fill it up with people and then sort of randomly, when someone dies, we'll replace it. Or more often, strategically, the justices will decide to retire when a president they like is going to appoint their replacement. And we'll throw in some sort of bitter partisan hardball. If the Senate is controlled by the opposite party of the president, then they can just try to block appointments. And that's what determines who controls the Supreme Court, because the two parties are fighting over the Supreme Court, right? This is the thing the founders didn't anticipate. The two parties are fighting over the Supreme Court. Who wins is decided by random chance, strategic retirement, partisan hardball. Is that a good way to staff the Supreme Court in a democracy? I don't think so. Can we do better? Well, yeah. It's not perfect, but I would like to say we're a democracy and there are different constitutional visions out there and they're legitimate. So I'm not going to say people who disagree with me about the Constitution are faithless, trying to destroy our beautiful republic. I'm going to say there are different constitutional visions out there, and if you can convince a majority of the American people, or at least, if you can win the Electoral College, because that's a little bit different, but if you can get your guy elected president, then I think you get to have some input in the composition of the Supreme Court, maybe like 2 justices. So if you say each president gets to appoint 2 justices per 4-year term, then you're going to bring the court back in line with success in presidential elections, which is not perfect, but I think that's the best thing to tie it to. And I think you can see, looking back through American history, when you stray from that, things get out of whack and you get conflict. So why does FDR feel he needs to propose a court packing plan? I said, because he got no appointments his first term. I don't know how far off the court was there from where it would have been if each president got 2 appointments, but you can go back through history and model that, right? Where are we now? We're a 6-3 Republican majority. If each president had gotten 2 appointments, we'd be 6-3 Democrats. So we're 3 away. Switch the partisan affiliation of 3 appointing presidents. When was the last time we were that far away? 1858, Dred Scott. And I think that's not a coincidence, because bad things happen when you have a Supreme Court representing the will of a party that represents a minority of the American people. And that's the fundamental argument for term limits.
I was going to bring that, which brings us to the point that you bring up, which is you said earlier that the Supreme Court, and you just said now, is controlled by a minority, and you view it in terms of the political the affiliation of the president who nominated the justices. And in many cases, we have seen that the split is 6-3 Republican appointees, Democratic appointees, which I guess brings the next question to debate, which is, ought the Supreme Court represent a majority of the country? Should the axiom elections have consequences really be the I guess governing axiom by which we understand the Supreme Court, or are there certain considerations of judicial independence that would be eroded if we decided to make two justices hinge upon every presidential election?
Should I take that? You take that?
Go ahead. I will give complaints. I'm lining up in just a second.
Okay. So I think that's a very complicated question because on the one hand, no, like constitutional rights aren't up for a vote. The court's not supposed to be a majoritarian institution. But two, like I said, there are different constitutional visions out there. And unless you're prepared to say, mine is the only legitimate one, and therefore the only legitimate court is the one with 9 of my guys, right, which people sometimes say, then I think fairness is like, if you win a presidential election, that gives you some say. How else are we going to do it? I'd also like to say something about the constitutionality of a term limit statute. Can I do that now?
No, absolutely, yeah.
Okay, so the big change for me with the process of the Reform Commission was I went in thinking you need a constitutional amendment, and then I was like, hey, you don't. I learned something new. And what I learned, one of the things I learned was we don't have 9 Supreme Court justices. We have more than that, because David Souter is a Supreme Court justice, and Anthony Kennedy is a Supreme Court justice, and they exercise the judicial power of the United States, and Congress can't reduce their salaries. Why can Congress not reduce their salaries? Because they still hold the office. So when Supreme Court justices or federal judges retire, they can resign, and then they're not judges anymore, they don't hold the office, or they can retire, and for lower court judges, we call this senior status. For Supreme Court justices, we call it retirement. But the statute says they can retain the office. And I was like, well, whatever, the statute says that, but I'm not sure that really means they're still in the office for Article 3 purposes. But there's a unanimous Supreme Court decision with a lower court judge, this is from like 1934 maybe, where there was a lower court judge who took senior status under an earlier version of this statute. Congress tried to reduce his salary. He said, hey, you can't do that, I still hold the office. And the Supreme Court agreed unanimously. So it seems to me that if a senior status judge or a retired Supreme Court justice still holds the office, and what we're saying is after 18 years, you assume this status, like you're not part of the regular 9 making the ordinary decisions, but you're still a Supreme Court justice, then you haven't removed them from office. Now the difference here, right, the big point is this is mandatory after 18 years. Currently it's voluntary. That's a big difference if you want to have conversations about how it affects judicial independence as like a non-textual separation of powers principle. I think those are conversations worth having. But if you want to say it removes them from office, I don't see how voluntariness makes the difference. And here is my homespun folksy analogy for it, something that might appeal to Justice Gorsuch, right, because he likes those. Suppose that you are sitting in a chair in your office, and I'm like, hey, here I am, talking to you. And we agree it's a baseline rule. I cannot make you leave your office, right? You see the analogy. But we also agree that if you stand up from your chair, you have not left your office, right? And now I'm like, you've been sitting there long enough, or I say like going forward, starting tomorrow, after 2 hours, you must stand up from your chair. Have I violated the rule against making you leave your office? I don't think so. I just don't see how that follows. So that's why I think this can be done by statute. It's surprising to me that this is the statutory scheme we have for retirement. I didn't know that. It's surprising to me that David Souter is still a Supreme Court justice, although I'm happy about it. It's surprising to me that a unanimous Supreme Court said this, but that's the law.
So the case he's referring to is Booth versus United States. It is from 1934, and he's mentioned Congress had created a structure where judges could sort of semi-retire and get this reduced caseload and so on, but they couldn't have their salary reduced. And if you did like a word cloud with the words in that decision, one of the biggest words in the cloud might well be may. Over and over again they say the judge may elect this status, may. The difference between sort of the voluntary sort of acceptance of a decreased caseload, or even in the Supreme Court case, and I'm dubious, I with all due respect to Justice Souter and Justice Kennedy, I have always thought it strange that a justice could somehow then like kind of retire from the Supreme Court but just become like basically a First Circuit judge and hear these cases. But the difference between that structure for senior judges, the voluntary one, and the mandatory sort of, the mandatory version of this, is the difference between retired and fired. There's a very, very big difference between these two things. Between a judge saying, okay, I'll take fewer cases now, and the Congress and the president saying, okay, you'll take fewer cases now. Congress can change the responsibilities of the court as a whole within some limits, but we've never seen them come in and try to do this forcibly to sitting justices. To the extent that that proposal actually reflects the court's decision in Booth versus United States, which I don't think it does. The court really was focused there on this voluntary status. I think that's probably grounds for recalibrating Booth versus United States, rather than creating this first of its kind stripping of duties from justices after they've been on the court for a time. I mean, I do want to circle back to all of the practical problems I see with this, but I just don't see support for this proposal in Booth.
In response to that, or we can move on to the next one.
I gave you my view.
Okay.
You can read Booth. See what you think.
Go read Booth. There we go. You have extra. You didn't know you were going to have a reading assignment coming into a guest lecture, but here we go. You can go forth and read. So the next question is.
Can I get to the practical problems?
Yes, absolutely. No, go ahead.
Because like I said, and I'm being kind of pushy here because this is the main thing I hope you'll take away from my remarks here. Because it is the things that really weren't obvious to me when I joined the commission, but which the more we talked about it, the more my friends talked me out of term limits. Because again, I think some of the benefits are obvious. But let me just click very quickly through what I think are the downsides to this. And it affects each of the three branches, but I'll start with the justices. When we take Supreme Court status, a Supreme Court appointment, and instead of being sort of the capstone of their career, for a justice. And now it's something that maybe you get when you're 50, 55, and you have until you're 68, 73. We're now going to have the prospects of sort of a market for retired Supreme Court justices. I know they'd have the option to stay as senior justices, hear fewer non-constitutional cases. I don't assume that they will all want that deal. They may well want to do something else with their life at that point. I think we should tread very lightly before we forcibly retire justices or decrease their role, because we don't know what they'll do next. I don't think that some of the doomsday scenarios are like, oh, they'll become lobbyists or something. I'm not worried about that. I do worry about justices using their time on the court consciously or unconsciously creating an audience for themselves. I worry about mundane ideas, like some firm creating like a high-class arbitration firm that would be staffed by Supreme Court justices, where justices who get paid $10 million a year, retire and decide private disputes for us. I just don't know what they're going to do next. But the one thing I do know is I don't want the justices, while they're on the court, hearing a clock ticking in the background and wondering what are they going to do after year 18. Once we create that, I don't know the justices will even want to stay on for 18 years. But anyway, that's one thing I worry about with the court. I'm very worried about what this would mean for presidential politics. We saw what happened in 2016 when there was a vacancy on the Supreme Court and it became the most pitched knockdown drag-out fight we've ever seen over the Supreme Court, or one of the most. The term proposal, the new appointments every 2 years proposal, that means that there would basically be vacancies up for grabs, guaranteed, with every presidential election. If you liked 2016, you would love the world in this, where you know there's going to be at least 2 seats. There's going to be 2 seats, maybe more if somebody dies or retires early. If you like the idea of candidates running for office with explicit lists of justices they would want to appoint, we should prepare for that. I liked Trump's list in the sense that I liked some of the judges who were on that list. That's no way to run a country, having presidents run with explicit or implicit running mates from the judiciary. Also, oftentimes advocates for term limits say it's fairer, or it seems more equitable, or just better if you could spread Supreme Court appointments evenly across presidential administrations. So every president gets roughly the same number of appointees. That actually had appealed to me when I was coming in. I thought that was a virtue. I don't think so anymore. I think it actually really would make concrete this perception that Supreme Court seats really are the spoils of presidential politics. Not just politics, but presidential politics. That's already largely a perception we have in politics, and I think if anything we should push back against that. We shouldn't treat the Supreme Court as just something to be handed out by presidents. And then the last thing I'm worried about is Congress. I am worried for the tit-for-tat scenario. Once we open the door to the idea that Congress can structure and restructure the Supreme Court, put some justices on a back bench and some on a front bench, that'll be the first time and not the last time. If Congress can announce that the senior justices, once they've been there 18 years, they need to do less, you could just as easily flip that argument around. Maybe the junior justices are the ones who should have a break-in period. They should sit on the back bench like the JV team for a few years. I think that would be a terrible idea too. But once we've established that the president and Congress can do this, well, anytime there's a change in the presidency and Congress, there's going to be at least some people advocating for a new court reform bill that shifts us around. And to the extent that there's a pool of justices, old retired justices on the back bench, like a shadow court waiting to be called into action, those political fights will get even worse, and also recusal fights will get even worse. If I'm a litigant and I don't like the current 9 active justices, but I know the first one that would be called from the back bench if one of the justices was recused to jump in, if I know who that is, I would fight very hard to find some kind of grounds for a recusal. I don't want to overstate that one. Recusal is a very narrow thing, but from the justices to the presidents to the courts or to Congress, term limits in their current proposal strike me as a way to make each situation even worse.
Wonderful. So, no, it's all right. So we, thank you so much for the discussion on a topic that I think has been, if anything, more than court packing. The term limits discussion has been one that we've had on this campus. We've had debates at our debating society about this. So this is definitely a question that we are all wondering about. So for the, I think, last question that we can do, I can pitch before we open it up to audience questions, has to come back a little bit to first principles, but not in the same way. There's been a lot of discussion recently about the court's legitimacy. If you go on New York Times, Washington Post, Fox News, CNN, anywhere you get your news, and you see a story about the Supreme Court, one of the words you will see probably in the first 2 or 3 sentences is the word legitimacy. I did a quick Google Trends search, which is not the most scientifically accurate in the world, but you can clearly see around 2016, there is a sharp spike in searches for the term Supreme Court and legitimacy or legitimate. To bring the word cloud back into it, I did another quick search of the final report that the commission issued, and it mentions either the word legitimacy or legitimate 72 times, which rounds out to, this is my politics major math, once around every 4 pages or so. So if you put a word cloud up, that would be one of the central words in the word cloud. Yet there are various warring definitions of judicial legitimacy. For some, the court's fidelity to precedent and individual rights, especially those that have been newly recognized within the last half century or so, is the key. For others, fidelity to the original meaning of the Constitution and respect for the democratic process is the true substance of legitimacy. And of course, these are not binary options. There's a lot of interplay between all of these different sources of the court's legitimacy. What then, in both of your opinions, is the source of the Supreme Court's legitimacy, and under what set of circumstances can it itself undermine that very legitimacy?
Is it my turn?
Yes, sir.
Okay, so I'm not going to jump right into that question. I'll try to get to it. But so first, on the practical problems, I think those are all really interesting questions and worth thinking about. My basic reaction to them is every other country in the world seems to survive that way, right? No one else has life tenure. So whatever the practical problems are, my suspicion is that they're surmountable. And then legitimacy, I don't know. People do public opinion polls to figure out if the American people think the court is legitimate. And I'm not sure exactly what standards they're using. But I have my own conception, I guess, of what makes a Supreme Court decision legitimate or what makes the court as an institution legitimate. But I'm not sure that matters because it really is sort of like public confidence in the court and, whether people will clap their hands because they believe in Tinkerbell. Do people still know this? It's like, clap your hands if you believe Tinkerbell comes alive in Peter Pan. See, our culture is so fragmented. But, the American people have to think this. And here's what I would say about that, and it goes back to the question of whether this would make the court, term limits would make the court more or less political. I think in one sense, if you're like, each president gets 2 appointments, people would look at that and be like, yeah, that's political. So the input might seem political to people. I think the output would not. So suppose we had term limits and each president was getting 2 appointments and the composition of the court tracked basically the success of the parties in presidential elections. I think that people would look at the decisions that the court was issuing and say, you know, the court's not being really political. It's being pretty reasonable. It's being kind of statesmanlike. And the reason for that is that the Supreme Court is always going to be political in the sense of making contestable decisions based on vague constitutional provisions that inevitably involve value judgments. We could have a different constitution. We could have maybe a hyper-deferential style of judicial review, and that wouldn't be going on, but it's not what we have. It's not the world we live in. The Supreme Court is making contestable decisions that involve value trade-offs. But the thing is, your politics don't look political to you most of the time, in some sense. You're like, this is my worldview. What the court is doing is common sense. And if it's embodying a different political worldview, then it looks like ideology. And the reason that people think the Supreme Court is political now is because it's reflecting a worldview and an ideology that most Americans don't share. It's reflecting this minority worldview. And so I do think term limits would, in a sense, make the court appear less political because it would be more in kind of the mainstream of American political views, maybe, although I don't like to say that because it's not supposed to be making decisions based on politics, so maybe I would say constitutional vision, because I do think there are different constitutional visions out there. But if it's in the mainstream of American constitutional visions, it's not going to look so political. And then sort of last question, why did legitimacy trend in 2016? It's because the American people are not stupid and they saw that a seat was being stolen, right? So they know that there's a partisan fight going on. And they feel that there are sort of rules of engagement that should be followed. And I think, you know, 2 appointments per 4-year term is a pretty fair and neutral one that people would come to accept.
I mean, on legitimacy, and I keep circling back to Hamilton on this because I do think he got it right from the start. He understood that legitimacy for the Supreme Court hinges on 2 things. First, it does depend on the people's perception of the court. He was very worried in his writings on the court about the people having, the court winning the trust of the people. He understood this was incredibly important. Even when the court would sometimes be ruling in unpopular ways, you still had to win the people's trust. That in a republic, and basically a democracy, you could have this, later came to be called a counter-majoritarian force in our government that would push back against political majorities. So the court has to win the people's trust. But how would they do that? I think it's equally clear in Hamilton's writings that the court needed to win the people's trust in explaining to the people why what the court was doing was law and not politics. That again, overturn laws as a last resort, not a first resort. But above all, be bound by law, be bound by precedents, and now with originalism it gets very complicated. How do you weigh your understanding of a written law against a precedent? But even in making that judgment call, show that you're bound by something outside of your own sort of immediate political policy preferences. At all times, the court has to show that we're making decisions based on laws that we largely did not write and facts that we did not actually make up. That we're bound by all of these things. And so the court has to go about doing the work of a court and then explain to the people why that's legitimate. And the court hasn't always succeeded at that. I have a much, much more favorable view of recent decisions of the Supreme Court than a lot of my friends. But that's ultimately the task of the court, to decide cases not as a legislature, not as an administrator, but as a court in the ways that only a court does, and then convince the people that they're correct. A moment ago, Kim, you used the term the stolen seat. And this gets back to my view of the relationship between the court and presidents. I've never accepted the argument that the Republican Senate stole a seat from President Obama. I reject it because, again, I don't think presidents own seats on the court. I don't. And I'm overstating. I know you don't think that either. I don't mean it that way. But I think that there is not, or maybe you do, I don't want to put words in your mouth, but
Sort of. I would like, so I think it's hard to get there with the Senate, and I don't know exactly how to do it, but I would like a system where each president has equal influence.
I think it would be a terrible idea. We already have presidential elections that have become the everything elections, right? It feels like every issue is up for grabs because presidents and administration have so much power and so much discretion. And Congress does not act like a legislature anymore. It acts like a reactive body that just sits around, like sits in judgment of the world rather than actually passing laws. They just have hearings. Everything, it feels like in our politics, hinges on presidential elections. And this term limit proposal is a way to put even more everything into the presidential elections. Don't imagine not only how much more heated our presidential elections would be, this would all flow downstream to fights over electoral colleges. If the shape of the Supreme Court, or the personnel of the Supreme Court, depended even more tightly on the outcome of presidential elections, the Electoral College would become even more fraught than it is. And some of my friends might like that. I don't. I think Electoral College is a good thing by and large. But this is a way, judicial term limits is a way to put even more weight and heat into our presidential elections. At a time when I think some of the biggest problems in our politics is that presidents have too much power and presidents have too much gravity in our politics. And so I'm just instinctually in favor of anything that takes back from the president's power to make policy. And anything that takes back on the president's sort of gravity in our political process. And this seems like another way to centralize power, not just in presidents, but in presidential politics.
We don't have any more responses or last words on the issue. We will open it up to audience questions. So I will be handing off my microphone shortly. And okay, no, that sounds great. And then feel free to ask any questions that you might have. And if you could too, maybe just name what you study and year, if that's possible.
Sure. Thanks. Thank you both for coming. It's always great to see a debate rather than the one viewpoint, as is often the case at some of these lectures. So it was a great event. My name is Roberto. I'm a junior in the economics department. If either of you know the answer to this, since you were on the commission, feel free. But when we had the debate that Zach was alluding to in our debate society over the term limits, from my recollection, probably the argument that swayed people most against the term limits for the Supreme Court justices is the argument that they could just retire anyways before those 18 years. So like if I'm at year 14 and there's a president of my party, why can't I just do the strategic retirement anyways? And then like, does the system really solve anything?
So the answer is there are different ways to try to deal with that, and you could read the commission's report. It's great. It's got more than you would ever want to know about lots of things. But I think the simple answer is you retire at year 14 with the congenial president who appoints your replacement for the remainder of your term, not a new 18-year term.
I would just say, in an era when norms fall away so quickly, I just want to reiterate, I'm really worried about what it would mean for a justice to not just sort of serve till basically the end of his or her career, but have a whole other chapter in their career. It just popped into my head when you mentioned Justice Souter. When he retired, didn't you write a piece about Souter of Cincinnatus?
I did.
Okay, so I'm not a Souter guy, I'll be honest. But one thing I really did admire about him was the way he said, I think I've had enough of this. I don't want to be in Washington. I don't want this power anymore. I'm going back to New Hampshire. And obviously that might be motivated reasoning on my part because I was not particularly on board with most of his jurisprudence. But I think there's something really noble about that. And I remember being struck by that piece. We just don't know what things would look like once justices, like I said, suddenly realize they're going to have a whole third act or fourth act after that. And so I don't take for granted that the justices would stick around for 18 years. Once there's all these other sort of retired justices roaming the landscape. I very much like this idea that justices basically serve till the end of their career and then hang it up and maybe write a memoir or something. I'm very wary about this other approach, as much on the norm side of things as anything else.
All right. Thank you. Hello, my name is Daniel. Daniel Shaw, class of 25, politics. If it's all right, I have one question for Professor Roosevelt and one for Professor White, but feel free to answer both of the questions, I suppose. Firstly, for Professor Roosevelt, how do you deal with the charge that by giving each president 2 appointments to the court and then tying it to the election, the presidential election as you have proposed, that you turn the Supreme Court into essentially a worse and indirectly elected legislature? And secondly, for Professor White, how do you propose dealing with the inconsistent norms the Senate has set, largely under Republican leadership, regarding when it is appropriate to act on a presidential nomination absent term limits?
You have an order of the questions.
Okay. I'm not going to answer your question because I was actually thinking about mine, so I don't think I heard yours. Unless it's a great one, and then maybe I'll piggyback off your answer. But so my answer to my question is, look, I don't think it's going to change the character of the Supreme Court. I think you'll still have justices deciding cases that require them to balance values in implementing vague constitutional provisions. What I think is we all know it matters who the judges are, right? The Warren Court is very different from the Roberts Court. And so how do we decide who the judges will be? Should it be chance, strategic retirement, partisan hardball, or should it be something regular and predictable? Should we tie it to something that everyone understands where, like, the American people can have some say in it? I think that's better. And to just try to reinforce that, what are the decisions that we like? I said, like Brown, Loving, maybe some sex discrimination cases, maybe Obergefell, I don't know. What's going on in those cases? The Supreme Court is enforcing the will of a national majority against local majorities, against outlier states, basically. And we tend to like it when the court does that. So when the court represents the national consensus with these vague value-laden provisions, it gives us decisions that we end up liking. What happens when the court represents the minority? Well, one thing that happens, I said, is it's tempted to undermine democracy, to keep the minority in power. And also it represents the constitutional vision of that minority, and the big example of that is Dred Scott. So I think a court that represents the majority of the American people, and again, it's in terms of their constitutional vision, however you sort of cash that out. It's not supposed to be just politics. But there's ambiguity, there's room for different visions. But a court that represents the constitutional vision of the American people has a much better track record, I think, than one that represents a minority.
And you said you're in the politics department here. I'm a big fan of the politics department here because I've gotten 2 amazing RAs out of it over the years. Most recently, Tori Tinsley, who graduated. I see some heads nodding. She's wonderful. So my question was, how can we really grapple with these issues sort of neutrally in good faith in an era when there's been real changes in norms and pretty flagrant hypocrisy from Republican senators in their treatment of the Scalia seat and then the Ginsburg seat? Is that a fair way to put the question? It's a great question, and I grapple with this a lot. I was very much okay, to say the least, with Republican senates holding the Scalia seat open through the presidential election. Again, it's something I've been writing about for a long time. The Senate did not need to move forward on nominations. I was perfectly fine with that, and obviously it lined up with, we didn't know at the time, we didn't know who was going to win in 2016. If anything, I was stunned that President Trump won. But in hindsight, obviously it worked out well for my preferred version of Supreme Court jurisprudence. I think it's impossible to hold up what Republicans did in 2016 and then what they did in 2020 after Justice Ginsburg passed away and the Republican senators fast-tracked their review of Amy Coney Barrett. It was hypocritical. There's no way beyond it. After the fact, some Republican senators or their supporters said, well, actually, in 2016, what we said was when the president and the Senate are of different parties, you should wait till the election. But when they're in the same party, it's different. That was not, believe me, that was not the thrust of the 2016 argument. It was said a couple of times here and there, but I think it really takes a willing suspension of disbelief to say that's what happened in 2016. It was just total hypocrisy. And for me, the only answer for that is a willingness to call out your own side when they do that. There's just no way around it. At the end of our commission, we were given the option of writing a sort of a short individual statement at the end, just 2 pages, so it wouldn't be like an arms race of separate statements. And I think I closed with the basic point that we're in an era where all 3 branches of government need to, they are all in need of reforms, but they have to be internal reforms. That presidents, Congress, and the courts need to improve themselves drastically. And that requires partisans of any part of those branches, or any of those branches, or whoever's in office at any given moment of time, to be able to take a step back from the immediate political fight and say, structurally, this is wrong. I joked before about how I hate strategic retirements 50% of the time. I can make that joke, but like the next time a conservative justice retires under a Republican president, there has to be a willingness to say, whatever one thinks of that justice or whatever one thinks of that president or who the next nominee is going to be, this does reinforce the view that this is partisan. I wish the justices would go back to the old norm of serving for a long time and then deciding it's time to go. The parties, since they polarized over constitutional methodology, it obviously is more complicated now, but we have to admit there's a real cost to what we have now. And so it's a long way of answering your question, which is, at the end of the day, it's going to require anybody who's engaged in politics or political punditry to be willing to call out your own side and say, that was hypocritical, that was the wrong way of doing it.
All right. Well, if you have
Yeah, wow, what's wrong with the Senate? I'll tell you what's wrong with the Senate. It's that senators representing 18% of the American people can control the Senate, right? They can be a majority of the senators. So you've got this minority control, and that would be sort of just weird if it didn't have a partisan inflection, if it didn't line up with the party system. So you've got a minority political party empowered in the Senate, and I think that does cause problems.
All right, I think we have time for one more question. So if anybody, gentlemen out here.
Thank you for this debate. I am Jim from, I'm a friend of the Trenton Monthly Meeting, and I came here out of concern of what is happening. And I will ask this question. Do you think it's possible for a procedure to remove judges that have proven to have immoral decision-making through conflict of interest?
Like Clarence Thomas and Alito.
Thank you.
Well, I'll say, yeah, we do have that process, and it's impeachment. But, like so much of our constitutional system, I think it's kind of fatally compromised by the party system. So, my view is lots and lots of features of our constitutional system don't work. Certainly not as well as the framers expected that they would, and it's because of the party system.
I mean, I have a very different view of the party system and also the Senate, but on this one question, it's fundamentally, this is the basis of the court's legitimacy at all times, to take seriously the recusal rules. And here you do have the justices sitting in judgment of themselves. It's that kind of question I was getting to before, of taking a hard look at yourself and deciding whether you're in the right or the wrong, and being willing to make that judgment and stand in front of the public and do it. The recusal statutes, the recusal statutes have long been there for the lower courts. For the Supreme Court, it's always been much more delicate. But the justices still have an obligation to take them seriously, these rules that they put upon themselves, and to be willing to grapple with this and stand forthright on this. I have a different view of the Alito situation and the Thomas situation with respect to conflicts of interest. I don't think they violated the recusal law, the recusal rules, in terms of having a conflict of interest in a case. And I'm somebody who, just for the record here, has said over and over again that what happened on January 6th was an insurrection within the meaning of the Constitution. I've been a vocal never-Trumper since the moment he came down that golden escalator or whatever. I've been against it from the very beginning. I have a very strong view of what happened on January 6th and what a constitutional travesty it was. I don't think that Justice Alito had a recusal requirement that he violated, and I don't think that Justice Thomas did either. But that's a hard question that's taken a lot of reflection, and I think should be taken seriously by everybody. Can I ask you a question? Not about the substance. What's the Trenton meetings?
I'm a friend of the Trenton Monthly meeting, which is where the so-called Quakers meet.
Okay. Thank you. I hadn't heard of it. It sounded very interesting. Thank you very much for your question.
Alrighty, I think that'll do it. Thank you so much, everybody, for coming, and give a round of applause for our two wonderful debaters.